This is a passage which I am going to dictate you at a speed of 120 word per minute. 5 seconds to go. Get ready. Start. Heard Mr. S.D. Learned Council appearing for the appellant. We have also heard Mr. B. Bhuya, Learned Additional Public Prosecutor, Assam, appearing for the state oblique respondent number 1. None has appeared for the informant oblique respondent number 2. Para. The judgment and order dated 3/12/18 passed by the Learned Additional Session Judge Gwalpara in session case number 25/2016 convicting the sole appellant Urup Rabha for committing offences under section 364A 302 201 of the Indian Penal Code and sentence him to undergo rigorous imprisonment for life for committing the offence under section 364 bracket A and 302 of the IPC and to undergo rigorous imprisonment for 5 years for committing the offence under section 201 of the IPC and also to pay fine of rupees 5,000 in default to undergo rigorous imprisonment for a further period of 1 year, with all the sentence running concurrently, has been assailed by the sole appellant by filing the present appeal. Para. The prosecution case in a nutshell is that on 2/8/2014 an Azahar was lodged before the officer in charge Asia Police Station by Sri Nikhil Chandra Kolita. Informant that 30/7/2014 at around 3 p.m. Someone had called his brother-in-law Sri Jogendra Naran Kolita bracket digest over phone to Fafanga Part 2 Gaon, Bormahara on the pretext of providing him with rubber. On receiving the phone call, his brother-in-law went out of his house in his motorcycle bearing registration number AS18A6670, but thereafter he went missing. Since his brother-in-law did not return home at night, extensive search was made looking for him, but the victim could not be traced out. Later on, around at 10 p.m. in the evening, some miscreant had called up his younger brother, viz. Sri Soilen Das, in his phone bearing number 9707 from the phone of his missing brother-in-law bearing number 8121 and said that Jogen Kolita was with them and demanded ransom of rupees 10 lakh for his release. Thereafter, they switched off the mobile phone. On such ground, a prayer was made to initiate necessary action in the matter. Para. On the basis of the Azahar dated 2/8/2014, Asia PS case number 107/2014 was registered under section 364 bracket A of the IPC, whereafter investigation had commenced. During the course of investigation, dead body of Jogendra Nath Kolita was recovered and hence section 302/201 of the IPC were added. 5 persons, including the appellant, herein were arrested by the IO and the dead body was sent for post-mortem examination. The IO had claimed that the dead body of the victim was dragged out in presence of magistrate on being led by the appellant and another accused, Orupam Rabha. Upon completing of investigation, the IO had submitted charge sheet against all the 5 accused persons. Based on the charge sheet submitted by the IO, charges under section 364 bracket A 368/302/301/34 of the IPC were framed against the accused person, which was read over and explained to them. However, since the accused person had pleaded innocence and claimed to be trial, the matter went up for the trial. Para. The prosecution case was entirely based on circumstantial evidence. The prosecution has also claimed that based on disclosure made by the appellant, the dead body was recovered on being shown by the accused. The accused has denied the charge brought against him. The defense side, however, did not adduce any evidence. Upon analyzing the evidence adduced by the prosecution side, the learned trial court had convicted the appellant Orup Prabha under section 364 bracket A 302/201 of the IPC and sentenced him as aforesaid, while acquitting the four other accused persons due to lack of evidence against them. By referring to the impugned judgment and order dated 3/12/2018 passed by the learned additional session judge Gwalpara, Mr. P.K. Das has argued that there is no evidence to support the prosecution story that the dead body was recovered on being laid by the accused appellant. However, even assuming that there was evidence within the meaning of Section 27 of the Evidence Act, even then the same would at best be an additional link in the chain of circumstances. The present being a case based on circumstantial evidence, the prosecution, according to Mr. P.K. Bora, has failed to establish the chain of circumstantial pointing toward the guilt of the appellant. Mr. P.K. Bora submits that there is no evidence against his client as so to sustain the conviction, and thereafter the impugned judgment and order dated 3/12/18 be set aside and the appellant be set at liberty. In support of his above argument, Mr. P.K. Bora has relied upon the following decision. Altar Singh vs. State of Rajasthan 2004 10 SCC 657. Yusuf vs. State of West Bengal 2011 11 SCC 754. Mustaqim vs. State of Rajasthan 2011 11 SCC 724. Mr. Bhuya, learned additional PP Assam, on the other hand, had argued that the evidence on record clearly goes to show that miscreant had called the victim of a phone and later kidnapped him for ransom. Even after receiving the amount, the victim was murdered and thereafter the dead body was kept hidden inside a forest, which was eventually dug out by the police on being shown by the accused person. Under the circumstances, it cannot be said that there is no evidence against the accused person so as to sustain his conviction. On such ground, Mr. Bhuya submitted that the conviction of the appellant does not call for any interference by this court. We have bestowed our anxious consideration on the arguments advanced by the learned counsel for both the parties and have also carefully gone through the evidence brought on record. Since the basic plea of the appellant is to that the effect that there is no evidence to establish the chain of circumstances pointing toward the guilt of the appellant, it would be necessary for us to embark upon a brief discussion as regard the evidence laid by the prosecution side. As noted above, Sri Nikhil Kolita is the informant of this case. PW1 has deposed before the court that the incident had taken place on 30th 7 2014. On that day, his brother-in-law Jogendra Kolita was called by someone over telephone and then he went out but did not return back to home for the whole day. His elder sister had informed him that his brother-in-law did not return home and then he went to the house of his younger brother-in-law Soilendas and learned that he had received a call whether the person on the other side had told him in broken Assamese voice that his missing brother-in-law was in their custody and demanded the ransom amount of rupees 10 lakh for his release. On the next day, he had lodged the Azahar at the Asia police station. Exhibit 1 was the said Azahar and Exhibit 1/1 was his signature. This stop. Thank you.